Ladies and gentlemen, welcome. Thank you very much for joining us today for today's IR Law webinar session for this month. Some of you have seen in the name list have attended our previous sessions, and we hope to see you again in our future sessions. We see some familiar names who've attended our conference as well. I hope you enjoyed it. And I'm very sure today you will enjoy our present discussion today, which is handled by Mr. Amardeep Singh, Toor Amar Singh, who happens to be the partner with Lee, Hishammuddin, Allen, and Gledhill, one of the topmost legal firms in Malaysia. The title of today's webinar session is Effective Downsizing, which is managing retrenchment exercises. But before beginning in this webinar session, just to introduce to all of you myself, I'm Raja Vishnu, consultant with IR Law. What we do in IR Law is we provide consultancy services in human resources and specifically on industrial relations advisors on your day-to-day HR operations. We also handle cases at the industrial court as well as to the labor court as well. We're not a law firm, but a consultancy firm. And we provide a lot of other services to our clients. And those who wish to know more about IR Law services, please email inquiries to inquiries, ENQUIRIES at irlaw.com.my. Thank you very much. So before going on further, I'd like to properly introduce Mr. Amardeep Singh, who will be our speaker for today, specially invited today to present on effective downsizing, managing retrenchment exercises. Amardeep actually handles both litigation and advisory matters on all aspects of employment and industrial relations law. He also advises corporate clients on immigration laws and on management of your foreign workers and expatriates, as well as employment-related tax laws in Malaysia. He has contributed several articles to International Law Reports published by the Malaysian Current Law Journal. Recognized as a rising star in the Legal 500 Asia Pacific 2020 ranking, Amardeep has been commended for his ability to present to clients in a clear layman's way without overt legal jargon. I really like that. Present your, give presentation in a layman's way without any legal jargon. That's what HR and IR always looks forward to. So he is a graduate of University of West of England, Bristol, and a member of the Honourable Society of Lincoln's Inn. Amardeep was called to the Bar of England and Wales in 2012. He was admitted as an advocate and solicitor of the High Court of Malaya in 2013. Okay, ladies and gentlemen, without further ado, I'd like to present to you Mr. Amardeep Singh. Thank you very much.
Thank you very much, Vishnu, for the introduction. Nice to meet all of y'all. I always do enjoy coming down and speaking at IR Law conferences and IR Law webinars. Unfortunately, we can't do this face to face, but I don't think the experience would be anything less or short, or you would be shortchanged in any way. Vishnu, if I may, I can't seem to be able to share. Okay, I think I can do that. Just give me a second. I'm always not the best at technology, as you can see. Okay, so today's topic, as we all know, half of us are probably, or if not most of us, are still stuck at home listening to me, fortunately or unfortunately, as the lockdown creates a lot more uncertainty, and it doesn't seem to be stopping anytime soon. In fact, I just read that unfortunately, even one of our vaccination centers seemed to have had a cluster of almost 200 workers that were found to be positive. So it doesn't seem like this lockdown is going to be ending anytime soon. As we know, the NSC has said that a few criteria needs to be met before they would consider moving from phase 1 to phase 2. Khairi over the weekend said that we have already hit 13% of our vaccination rate. Unfortunately, the cases is also one of the factors. The cases have moved from 4,000 cases at one point, where we looked like we were going to hit the target of 4,000. in the last 1 week or so, it has escalated almost double, 9,000 to 8,000 cases. So it doesn't seem like this lockdown is going to end anytime soon. And therefore, only essential services are going to be able to operate from the offices. So this, I get frequent messages from my clients and calls from my clients because it causes a lot of disruptions to their businesses. And of course, inadvertently, it will also then impact your economic growth, right? And you'll then be left with, employers will be left with the decision that, it does not want to make, but it has no choice whether should it consider a reorganization. Is it too early? Do I have just cause and excuse already to carry out reorganization? Must I wait any longer? Because as a company, as an employer, obviously, if your company has been in the green for the last 10 years, and now suddenly you're hit with a lockdown, right? You're going to see a shift in your sales. You're going to see a shift in your financial statements. Now, so then the question arises, must you actually wait for your company to go in the red before you can carry out a reorganization? And if you're going to do so, which employees must you focus on? And how do you focus on those, right? Obviously, it doesn't make sense to remove everyone from a certain department. So you probably have to eliminate many different employees from many different departments. And today, that's going to be my focus of my presentation is you have decided to carry out a reorganization. What will the court take into account if this matter escalates to the industrial court later, right? So just some statistics for y'all that I extracted from the employment insurance system, right? It showed, I thought this was one of the best statistics to show the loss of employment or the amount of reorganizations or retrenchment exercises employers are undertaking. So this is some worrying stats. You would see that the numbers actually picked up in January this year. It could be an indication of moratoriums that ended in December, but you would see that in December there were about 6,800 cases. In January, the applications increased to about 8,004, and in February, similarly, it came down, but it was still higher than what it was in December. In July itself, in just 2 days, they have recorded 764 applications, right? Some very worrying figures. So today, that's what we're going to be talking about. We're going to be talking about retrenchment. So before we go any further, I'm sure all of y'all are IR law practitioners or have been exposed to industrial relations in Malaysia, will know that the bane of existence of every IR practitioner is the Industrial Relations Act, right? If you're unionized, even worse. If you're not, your bane of existence would be Section 20 of the Industrial Relations Act, which provides security of tenure to employees. In other words, in Malaysia, an employee cannot be dismissed unless the employer has just cause and excuse, right? And that is provided by Section 20, as you can see in the second bullet point. So if he is dismissed without just cause and excuse, the employee has the right to go to the Industrial Relations Department and seek to be reinstated, right? Now, it's unlike the systems that you have in, for example, Singapore, right? In Singapore, it's a country where you can fire and hire at will, right? Well, almost. You can hire and fire at will, as long as there's no express breach of an implied term or an express breach of any terms of the employment contract. You can hire and fire at will. But in Malaysia, you need just cause and excuse. And the three common grounds are, firstly, poor performance, secondly, misconduct, and the third one being redundancy, retrenchment. So retrenchment, which follows from a redundancy, is a dismissal. It's a direct dismissal. And so it will fall within the ambit of the industrial court. Now, once it falls within the ambit of the industrial court, then it will be subject to audit by the industrial court. And when it's subject to the audit of the industrial court, then you must ensure you comply with the law on redundancy, with the law on retrenchment. In other words, you need to ensure you comply with the test that has been put forward before the industrial court. Now we look at what is retrenchment, right? Retrenchment, the simplest definition is this. It is the discharge of surplus of labor, right? In other words, an employee you no longer require is discharging his services, right? In Malaysia, it is tried law that an employer has the managerial prerogative. Sorry, did someone? Okay, yeah, sorry. In Malaysia, sorry, I think someone has not muted their. Okay, that's fine now. Okay, in Malaysia, it is tried law that an employer has the managerial prerogative to organize its business, to organize and also to reorganize its business. And to do so, it can look at various different reasons: efficiency, cost, budget, profitability, right? But the employer must ensure at all times that whatever he does, it is carried out for genuine reasons. In other words, there is no malice, there is no alternative motive, or for example, trying to remove an employee who's involved in unionism, right? So it must be for genuine reasons. So the two questions: should the matter later escalate to the industrial court? Assuming you have dismissed an employee on the grounds of redundancy, the two questions then is, firstly, was there a genuine redundancy? This is where the court will inquire into the grounds which the employer has put forward. So for example, if you have said, we carried out this exercise because it was a cost-cutting measure and the company's finances were in the red, the court will look into those, right? And the second question is this: has the employer managed the retrenchment exercise in compliance with accepted standards of procedure? Put simply, does it comply with best practices, right? So the first question, let's take the first question first. The first question is, what is the reason behind the reorganization? It must be a genuine reason. Not liking someone is not a genuine reason. For example, you must show the court, why is there a need to reduce the headcount? It can be many different reasons. Firstly, improve efficiency. Second one, productivity, or implementing a leaner organization. So in implementing a leaner organization, here what you're trying to do is, for example, if A reported to B, who in turn then reported to C, for example, a leaner organization is removing B. So A reports directly to C. The next is business profitability or loss of business due to economic slowdown. The common misconception that employers or HR practitioners often have is a retrenchment must be a result of financial reasons. So in other words, it must be because the company is not doing well financially. That's wrong, right? I had a case where, in the case which was filed at the High Court, subsequently even went to the Court of Appeal. And what happened in that case was this: the client was a research center. It was a research center for monetary authorities like Bank Negara, Monetary Authority of Singapore, MAS, Thailand, Bangladesh, within the region, Southeast Asian region, right? And this research center had 40 employees. Out of the 40 employees, 26 employees were support staff or admin staff. For example, HR, finance role, admin, and so forth. 14 of those employees out of the 40 were actually researchers. So only 14 out of 40 were actual researchers. So what the center decided was they wanted to move from a functional layout organization to a more expertise base. So then what they decided to do was they were going to bring down their workforce. They're going to bring down their workforce to 30 employees, to 10 employees, by 10 employees. So what they did was they cut their number of support staff from 26 to just 13. And they increased their number of researchers from 14 to 17, right? And the court said, yes, this was a genuine reorganization. they had an idea in mind. I will go back and even talk about the documentation that they had later on. But that's what the court said, that yeah, they had an idea in mind. It was never for cost purposes. And in fact, there was evidence that costs actually increased, because what they did was they merged roles. For example, finance and HR was merged. It was unfair to pay the old finance manager the same salary which he was earning before the roles were merged. So what they did was increase his salary. They in fact even increased the salaries of the researchers. So the cost of the center to operate actually increased. But the only difference here now was they were running a very tight ship of just 13 support staff, and their researchers had increased. So the first question is whether there's a genuine redundancy. It will be very thoroughly scrutinized. This is the most important question, well more important than the second one. And the court will not take your say-so. For example, it's not sufficient for you to say that my organization is more productive by having A report to C directly. The court will ask you how, why, explain to me, right? If you have said costs have reduced, the court will ask you, show me how, show me evidence that it's reduced. So what do you need to produce? You need to produce cogent evidence that such ground and the reasons thereof did exist. For example, there must be clear documentation to show the rationale of the reorganization, the purpose, the cost savings, if you're talking about costs, improvements in terms of efficiency due to the reorganization. But that is the purpose behind the reorganization. You must also then show how the affected employees were surplus to your needs. For example, if you have an employee between A and B, you must show how A is surplus but B is not. So the evidence, where can you get this evidence? As employers or HR practitioners, the easiest way of getting it, of course, if there is a rationale on the rationale of the reorganization, it must have been discussed at some level. If it was discussed at the board of by the board of directors, it will be in the minutes of your board of directors. If there were discussions between the top management, there will be minutes of those meetings. If there was a concept paper or a proposal, those are the documents that will show the rationale behind the reorganization, right? If, for example, there is studies or research that was done before the implementation of the reorganization, you can extract that as well. For example, this may be where you have a report from an internal or external strategy consultant. So there was this case earlier I was talking to you all about the research center, right? That research center, what they had was they actually had board minutes. It was minutes from a meeting of the governors, right? So board of governors meeting, where they had minutes showing that this reorganization had been discussed at a very high level 3 years even before it was implemented. And 1 year before it was implemented, there was a very thorough report that was put forward by the consultants, external consultants, I think it was PwC if I'm not mistaken. They had put a very thorough report, and about 1 year before the actual reorganization, there was a board of directors meeting again where it was approved. So the court looked into all these documents and said that, hey, this is something that has been thought of 3 years ago. Quite clearly, it was not something that they thought about overnight or within 1 month or 2 months. They even got external advice on how to implement a leaner and more expertise-based structure, right? The next is you must have documents showing, if you're claiming it is because of financial purposes, you must have documents showing poor financial standing. If it's because of reduction in sales, you must be able to show that there has been reduction in sales. I had one of these cases where I asked the client, what was the purpose of putting your employees on unpaid leave? And they told me it was because of reduction in sales, right? And there was some uncertainty caused because of the lockdown and things like that. So I asked them, okay, fine. Can you please give me your sales report and summary of your sales that took place during the material time? And they provided it to me, right? And what this report showed was in February, let's say, they sold 10 items. In March, it reduced, of course, because of the lockdown to maybe 7. In April, it reduced to barely anything, 2 or 3, right? And that's where they said, that's why we had to put our employees on unpaid leave. And then I looked at it and I saw May and May and June, May and June was actually double of what January and February were, right? So in cases like that, the court is not going to be with you. The court is going to look at it and say, yeah, fine, you had a bad month, you had a bad 2 months, right? Didn't everyone? You picked up in May. So the court is not going to be able to find that this was actually genuine, because quite clearly the employer in that case had jumped the gun. He should have waited. He should have seen how badly it would have impacted him down the road, rather than jumping the gun and retrenching the employee almost immediately. The next question then is, so this is pretty much all the documentary evidence that you need to look at. The next one is more of, what are the good practices that you should take into account when carrying out a reorganization? Okay, so this is the test. Had the employer managed the retrenchment exercise in compliance with accepted standards of procedure? Put simply, is just complying with good industrial relations practices as the courts have laid down in various cases over the years. So the first one, and the most common question always, is termination benefits, right? So if you are an employee, you're retrenching employees under the Employment Act, then the termination and layoff benefits regulations very clearly states that they are entitled to termination benefits, and they are entitled to termination benefits in accordance to their years of service. So 1 to 2 years will be 10 days, 2 years, but less than 5 years is 15 days, and 5 years is more than 20. More than 5 years is 20 days. But Employment Act employees is not I think the concern. The more people will be more concerned about, what about non-Employment Act employees, right? My advice to my clients always is, acting out of caution, you should always assume an obligation to make such payments. And you can be guided by how the industrial court looks at it and how the industrial court awards compensation in the event your dismissal is found to be without just cause and excuse. And the reason being why is, these are employees that are being retrenched out of no fault of their own. They are being retrenched because of economic circumstances. They are being retrenched because of the company's circumstances. So you may want to then assume some obligation to make some sort of termination benefits as a precautionary or a safety net for them, right? And you may want to do so, especially in cases where the retrenchment is not because of financial reasons. It's because the company, for example, is looking to implement a leaner structure, or because the company is looking to move from a functional to a more expertise basis, right? So you may want to assume an obligation to pay in such cases, right? And how I always advise my clients is, you may want to look at an obligation to pay, looking at a sum of the minimum provided by the Employment Act and the sum of 1 month, which will be awarded by the industrial court if the dismissal is found to be without just cause and excuse, right? So a sum in between there would be very good for you to justify in the court. If this goes to the industrial court, it would be very good for you to be able to justify the court and say that we have actually complied. We have actually given him termination benefits. This, of course, is above and beyond. You've got statutory entitlement. You've got equitable entitlement, which is what I just told you. But do remember, you also have contractual entitlements. Contractual entitlements is monetary sums that they are to be paid in accordance with their contract. So if you have a handbook or collective agreement that states they are entitled to termination benefits, then you must comply with that. And if these employees that fall under the collective agreement or the handbook are also EA employees, then you need to give them the benefit which is greater. So for example, if it's 40 days per year of service, 1 month per year of service in the handbook, then they'll be entitled to that and not what is provided under the Employment Act. Right? The next is a simpler one, outplacement services. This is another thing that you can consider. Outplacement services these days they provide a range of services. For example, from career transition programs, consultation, emotional support, assistance with even resume, giving you guidance on how giving guidance to your employees on how they can conduct themselves during interviews, and also job searches. They also now do a lot of upskilling and reskilling for employees. And if your employee is, which something I'll address a bit later, open to mutually separate, to an amicable settlement or a VSS, this is something, the cost of the outplacement services is something that you can consider even lumping into the sum that you will be making to him as part of the compensation package. In other words, you can offer him a MSS, he agrees to the MSS, then you can tell him that, these are the outplacement services which we provide to other employees. If you're interested, we can give it to you. If you're not interested, it costs 2,000 ringgit per employee. We will put it into your part of your mutual separation. Okay, next we'll talk about is the code. Code of Industrial Harmony. I'm sure a lot of you all have heard about this. Now, the Code of Industrial Harmony is a set of good practices which the court will look into when deciding whether the company had complied with best practices before dismissing the employee. But be very clear that the court is actually not legally obliged to take into account the code. So in other words, the court cannot say that the dismissal is without just cause and excuse because you breached the code. But what the court will do is, would any of the breaches in the code have any impact on the retrenchment itself? Could he have averted the whole retrenchment exercise? Right? And this is where there are three areas that you need to look at. The first one is stage one, is the code talks about steps that you can consider taking before considering retrenchment. The second one is steps that you should take into account when retrenchment becomes necessary. And the third one is when retrenchment is necessary and you're picking up your employees, what you should take into account when selecting your employees. So these are the three stages of the code. So we look at the first stage. The first stage is steps that you should take into account before deciding steps to take into account with a view to try to avert the retrenchment altogether. Now, the code talks about limitation on recruitment, restriction of overtime pay, restriction of work on weekly days of rest, reduction in number of shifts, reduction in number of hours of work, retraining, transfer, and things like that. Now, the reason why this becomes relevant is this. I do until today have clients where, for example, the client is rehiring or hiring employees shortly or during the retrenchment exercise itself. Now, it is allowed if the role that you're hiring for is different from the role you had retrenched. But where there is similarities, for example, if it's a finance or an account role, if there are similarities in this role, the court could very well say that, why did you retrench this employee? Did you even consider offering this to this employee? You may argue that yes, we did, but unfortunately, the salary scale, they were both on different salary ranges. The court will then ask, did you even talk to him about it? Maybe he was open to taking the salary reduction, taking this role instead of losing his job. Or for example, if you are looking at a talent acquisition role and a HR role, you have made someone in HR redundant, but you have subsequently hired someone in talent acquisition. The court will very well look at it and say that, hey, there is very much a lot of overlap between HR and talent acquisition. Did you even consider offering this role to that person? Right? In 2009, the Ministry of Human Resources actually even issued guidelines. And in those guidelines, they also talked about steps that you should take into account with a view to avert retrenchment. And the steps that they included were the same 6 steps, but they also included 3 other steps. First was temporary layoffs, pay cuts, and also identifying vacancies in other companies. The last one, identifying vacancies, is actually also in our code, but it's in a different part. It's under part B, with a view that if you have decided to retrench someone, you should try to see if you can transfer him to another company. Now, the first 2 measures, temporary layoff and pay cuts, both of these are not in the code. But if an employer does take such steps, this is what will happen. If you do implement a pay cut, very likely you'll be faced with the case of constructive dismissal. You will then have to prove just cause and excuse. In just cause and excuse, you will say that I had no choice. It's either I put him on this pay cut where he walked off, or I do not put him on this pay cut and I have no choice but to retrench him. So that is my just cause and excuse. So while there is a fundamental breach of his employment contract amounting to a constructive dismissal, there is still just cause and excuse for doing so. right? Step two is when you have decided that you must carry out retrenchment exercise, then what steps do you have to take? And here is where the court says you should give early warning as possible. The reason why is you will not want to surprise your employee. You will not want to call your employee in on a Monday at 9 a.m. and tell him that he's retrenched and his last day is today and he has to walk out by the evening, right? He should be, at the very least, there should be some sort of consultation with the employee, some sort of discussion with the employee, and not be so arbitrary in dismissing them almost immediately. Second one is introducing schemes. For example, mutual separations, voluntary separations, and things like that. The other few you can see is retiring workers who are already above the minimum retirement age, trying to find for them work elsewhere, spreading the termination over a period. In other words, if you need to dismiss 100 employees over the course of the year, try to do it in stages. The whole idea of this is because the court wants to, the court is trying to see that in the event that you may be retrenched after 60 employees, and you find that that has turned the company around, your company is in the green or starting to be in the green, then there may not be the need to release the other 40 employees. The last one is something that always bothers employers is the selection of your employees. So here the code sets out certain criteria that you need to take, right? Objective criteria that you should take into account. For example, you need to be able to show that you should consider employees by looking into the need for efficient operation of your company, looking at their ability, experience, skill, occupational qualification, consideration for length and status. This is where your LIFO and your FIFO principle will come in. Age and family situation. Now, if you do not follow the LIFO principle, for example, if you have made an employee A redundant instead of B, you must have documentation to show why you did not follow the LIFO principle. Why didn't you follow the last in, first out principle? For example, if you have selected a junior employee over a senior employee because the junior employee who's been working with you 3 years performs much better than the senior employee who's been working with you for 10 years. You must be able to show this from your appraisals. Of course, if you do make such a statement and subsequently you're in court and you show the court, you tell the court that yes, the junior employee performs much better, and the court subsequently asks for the appraisal forms, or you look at the appraisal forms, you tender it, and it shows that both of these employees are actually average, or both of them were actually good performance, the court will be very slow to be with you, right? The court will look at it and says that, no, I don't see how you can justify this. You have just said that the junior employee was better, but the appraisals show otherwise. You have not produced a single document to show how the senior employee is worse off, right? So similarly here, the LIFO and FIFO principle are, the court will take this into account. They are generally more favorable of employees that observe such fundamental principles. However, you are allowed to depart from it. You're not bound by it if you're able to show good reasons why you need to depart. Like what I told you earlier, if you have a junior employee who's performing much better than a senior employee, it makes no sense to actually keep the senior employee. And I think this is probably one of the most important part is now you have decided you want to make an employee redundant. How do you do so, right? The more common one, let me work backwards. The most common one is a termination, right? You have no choice. You inform the employees that we are carrying out a retrenchment exercise. You issue a termination letter to this employee. They are all made redundant, and that's it. Now, what you can actually do in event that, for example, for employees who are not entitled to termination benefits, you can actually request them to sign a deed of release and settlement. So in other words, it's a one-pager document telling them that saying that they will not take action against the company. Now, it is still a dismissal nonetheless, but an employee who has signed this deed of release, he may be a bit more, it may deter the employee, or he may be a bit more reluctant to go and lodge a claim in the Industrial Relations Department. He would think that I have signed this form very clearly, which says that I would not take a claim against the company. If I do take a claim, I'll return these termination benefits and so forth, right? So you may want to consider introducing this deed of release and settlement. The other options are this. The most common one is a mutual separation. What a mutual separation is this. There is neither a termination, nor is there neither a termination, nor is there a resignation. The same way how both parties decided, I want to enter into this contract, right, by the company offering the employment, the employee accepting it, both employees have now decided that they want to mutually separate from it. So there is neither a termination nor a resignation. On that score, in actual fact, because they have mutually separated, there is no payment, there is no issue of salary in lieu of notice, right? Because it's a mutual separation, it's not a resignation, neither is it a termination. No party actually is supposed to provide notice, but it is very common to include the notice as part of ex gratia payment. In other words, a sweetener on top of whatever termination benefits they are supposed to receive. And this is a bit more creative, right? It's called a resignation on agreed terms, right? And it's one of my more favorite modalities if the employees are on board and they understand that they have to leave. A resignation on terms is this: the employee understands that I can no longer work in this company, right? There is a retrenchment exercise. I've been made redundant. Everyone in my department, or a good sum of employees in my department, have been made redundant. He then decides that I am going to resign on the promise of being provided with certain compensation, as the employer has told me. So what will happen is the employee will resign, the employer will then issue an acknowledgement of resignation letter, which, unlike your normal acknowledgement letter, will have all the terms and conditions of the compensation agreed between the parties, right? And the benefit of this is you will not need to go through the hassle of going through the PK forms, because the PK forms apply when there's a mutual separation or where there is a termination, but it does not apply when an employee actually resigns voluntarily, right? So this is where what are the benefits of resignation on terms or mutual separation. Now, firstly, you need to ensure you have a deed which is properly drafted. If you have an in-house legal team or you have your set of lawyers, make sure you have a template prepared, right? Have a simple template where all you need to do is change the name of your employees or the details of the compensation, and you can issue it to them. Secondly is ensure that you do not allow for any circumstances where an employee is able to contend that he was forced to sign the mutual separation agreement. Because you see what happens with a mutual separation or a resignation on terms, there is no dismissal. When there is no dismissal, he cannot go to the industrial court. Even if he files a claim in the industrial court, he will lose. The employee will lose because he has resigned. There is no termination that has taken place. So you mustn't, but what happens if you have forced him to sign, then the resignation or the mutual separation becomes forced, and he can then claim that it is actually a dismissal. So you mustn't force him, for example, to resign. You mustn't threaten him that sign or you're going to be dismissed. You mustn't confine him in a room. Give him time, right? Give him time to consider. Give them the mutual separation, give them the resignation on term, or give them the idea of it and tell them that, you know what, think about it over the weekend, come back to me if you want to. If they, for example, state, you know, I don't want to sign this agreement because I don't agree with this clause, do not tell them that, no, I'm sorry, we cannot amend it. Of course, if it's a material term, then you have no choice. If they don't want to sign it, they don't want to have that clause in that mutual separation agreement, then you're left with no choice but to dismiss them or to remove that clause, right? Also, this is a bit more legalistic. It's more likely to come up in the industrial court than your employee discussing with you. But your mutual separation or your resignation on terms must comply with contract law. Contract law states this: for a contract to be formed, there must be offer, there must be acceptance, and there must be consideration. Offer, acceptance, no problem. Consideration means there must be some sort of payment. Now, you cannot possibly tell an employee, an EA employee, who's worked with you for 6 years, for example, I will give you 20 days for every year of service if you sign this mutual separation. That is not consideration, because he's already entitled to it, to that under statute. nor can you tell an employee under a collective agreement or where there is a term in the handbook for retrenchment benefits that I will give you retrenchment benefits as seen in the handbook if you sign this mutual separation. The court will find that actually there is no consideration, right? This whole agreement is void because there is no consideration. He is being paid what he is contractually entitled to. So if, for example, if it's a statutory employee, you may want to consider a sweetener. For example, instead of 20 days for every year of service, give him 22 days or 23 days. That 2 or 3 days additional will become the sweetener for him to sign the mutual separation, right? Now, just very quickly, I'll just talk about reporting obligations. You also have reporting obligations as an employer. The more common one, of course, a lot of y'all will know, would be the PK forms, which you will need to submit to the Labour Department. Do not worry. I often get clients telling me, what if I give the wrong reason in the PK form? Will the Labour Department take action against me? If there is a mistake, you can always write into the Labour Department, correct any mistakes. The reason why the Labour Department ask for such information is for statistics purposes. So the first step is you need to submit 2 copies of the PK forms, which is in different various parts within 30 days. So the first deadline is 30 days before. The second deadline is 14 days after the date of retrenchment. And the last step is 30 days after the date of retrenchment, right? Each part of this form, the first one is about the number of workers involved, reasons for the retrenchment, cause for the retrenchment, etc. The second one is details of the benefits you have given the employee. And the last one is the particulars of emplacement or new employment, if any, right? You also need to provide a list of employees who are affected by the mutual separation or retrenchment. And this is usually done with step 1, which is 30 days before. I've also copied some, showed some sample forms. So you can see this is how the PK form looks like. Right. So this is where it states what are the reasons. So for example, here you can see it says there is a merger and things like that, closure of company, right? Okay. Now the other reporting obligations besides your EPF and SOXO is you need to inform IRB. This is you need to get a CP22A form submitted for local, CP21 form for foreigners at least 1 month before the date of the retrenchment. Of course, if there is a shorter timeline, it is fine, no issue at all. You also need to submit, if there are foreign workers involved, a form called Form PA2/13. You need to submit this to the Labour Department 30 days after the last day of employment, right? Now, these 2 obligations, CP22A form and Form PA, applies to all modalities, right? It applies whether it's a retrenchment, mutual separation, or a resignation on terms. Okay. Now, all right. With that, I will conclude my presentation today. If you do require the slides and want to make a request for it, you can email me at ast@lh-ag.com and I will send it to you. Thank you very much. Thanks for listening.
Okay, we have a few questions in the chat box, Mr. Amardeep. The first one is from Ahmad Safwan. What is the best practice, MSS or deed of release? Do we still need to notify JTK for the above 2 if the EE above EA?
Sorry, what is the best practice, MSS or deed of release? Do we still need to just notify? What is, sorry, what? Any idea what is EE? Ahmad Safwan is...
Mr. Ahmad Safwan, you can unmute yourself if you want to clarify that.
Oh, I think it means, does it mean expatriate employee? Oh, employee, okay.
Hello, hi, Safwan here. EE
Hi,
is
Safwan.
employee.
Oh,
sorry,
EE is
sorry.
employee.
Yeah,
No worries.
sorry.
No worries. I'm not very used to the lingos.
okay.
All right. Yeah. So, Safwan, MSS is a modality. For example, mutual separation is a modality. how do you do it, right? Termination of an employee is a modality. Resignation on terms is a modality. Voluntary separation is a modality, right? Voluntary separation scheme is a modality. A deed of release is the document you need to sign for the MSS, for the resignation on terms. You can even do it in a termination. It's a document saying that I will not take any action against the company in consideration of the payments that have been made to me by the employer, right? So that is a deed of release. A deed of release is more common with the MSS and a resignation on terms. For both these cases, for termination and for mutual separation, you still need to notify JTK. For resignation on terms, you do not need to, because it is neither a mutual separation or a termination. I hope that answers your question.
Okay, thank you.
Okay, next question is from Whitney. Is it mandatory for an employer to provide additional compensation if the employee opted to resign voluntarily?
Sorry, Whitney. Okay, is it mandatory for an employer?
For employer,
So what employers, my clients usually do, and how I advise them is this. When it comes to a retrenchment exercise, it's especially with small scale. If it's small scale, you're able to manage it a lot more easier. For example, you can able to have one-to-one talks. It's different when you're looking to retrench 100 employees. Then you will need to apply a standard that is applicable to all employees. So, example, if you're giving them 1 month for every year of service, it must be 1 month for every year of service for every employee. If you do give a group of employees 1.5 months, very likely the others will ask for the 1.5 months as well. So, I think someone needs to mute. Okay. So is it mandatory for an employer to provide additional compensation if the employee opts to resign voluntarily? Yeah. So usually what I'll always advise my clients is, if it's, you would have to inform the employee that you're going to, you will need to inform that employee that the employer is going to be carrying out a retrenchment exercise. Now, obviously the option would be, it will be a termination. In the event that employer goes down that path, what you will be doing is you'll be giving them 20 days for every year of service. But if subsequently the employee comes back to you and says, you know what, can I get more? You can then speak to the employee and say that, yeah, you know, I can consider, you know, if especially if you're willing to agree to a mutual separation or a resignation on terms, let me speak to management. Maybe we can see how we can increase the compensation. And then maybe you can increase the compensation to 30 days or 1 month for every year of service, which was your actual mandate. So you can do it that way strategically.
Okay, Miss Vivian, you have a question just now?
Yes, sir. Just want to check with you. If I have a company within the same parents company, like company A to B, right? And then this company A, one part of the team, they would like to transfer to the B company. For the commercial team, they want to transfer to the B company. But then in their contract, there is a handbook mentioned that they have the retrenchment benefit, they have the retirement benefit. But when they come over to our company, but we don't have such thing in our handbook. So, but how am I going to handle this scenario? We want this team to come to our company, but we want to have a clear cut. That means when they come to our company, they join us as considered a new staff.
Yeah, that's going to be an issue, because you see the whole that makes it a contractual entitlement. If you're going to transfer someone, you need to ensure that the transfer is on the same terms and conditions of employment and it's not detrimental to the employee. If it's not, then you're going to risk the employee walking out claiming constructive dismissal. So what you're trying to do can be seen as trying to circumvent giving them retrenchment benefits. So even if you transfer them across, you do not give them these benefits, and you subsequently do not give them, you do not recognize their years of service, very likely they will actually claim constructive dismissal.
Because I was worried that because since they have the retirement, if I assume their year of contract, year of service in my new company, so basically they are going to bring forward their retirement benefit as well, right?
That's right, because it's, I mean, in all fairness, the court is going to look at this very equitably and say that they were never dismissed, they were transferred. And if they are being transferred, then their years of service should also be transferred, should be taken into account.
But if there is a true structure of the company, basically it's like different benefit or whatever. So what we can suggest that they have to, within the current company, they have to settle all these things first. That means whatever we need to pay off to the staff, we need to pay. Then after that, all this stuff will join us as a new staff.
If that's an option, I've seen an employer who did that before. In other words, what they did was, before actually even transferring them over, because they refused to recognize their years of service. So what they did was they paid them off completely. There was no more years of service. When they came over, it was a fresh employment altogether.
Because it's a bit very contradicting. It's like they don't lost the company, basically they still got a job with them, just like this company A going to company B under the same umbrella, but then they just got a job, and yet we have to pay them the year of service. Then we have to assume that retirement benefit is something like the management look at it a bit not really fair to the employers.
Correct. So that's why the transfer should actually be on the same terms and conditions of employment. That's where the question comes up to whether the package in company, their previous company, is better than the new company, for example. And the court will not look at it in isolation, just the retrenchment benefits. The court will look at all the benefits and see whether in totality, was it better to be in the older company or the newer company. But if you do not recognize years of service, that itself, it's really detrimental to them.
All right. Thank you, sir.
No worries.
Okay, last question maybe from Ms. Angel. So after that, Mr. Vishnu can help to answer the questions. But right now I'm reading the questions from Ms. Angel. So resignation on agreed terms, decision is on employee where he or she see the company current situation and decided to voluntarily resign, correct? Not company give hint to the employee to resign to avoid the hassle.
Yes, that's right. So that's the whole idea of resignation on terms. I've got actually a case involving the British International School. It's a reported judgment. And in that case, what happened was the wife of the head teacher, so her husband was the principal, school principal, who was dismissed. And she was a very troublesome teacher, often missing, often on sick leave, often leaving early. So the school called her in and told her that, you know, we can't go on like this. So we are giving you 3 options. The first is, if you are not interested to work, you can leave, you know, and we can see, you know, whether we can work a package out for you. The second one is, you stay here, you improve and improve your performance. And the third one is, if you do not, then we are left with no choice but to take disciplinary action against you, right? If you do not improve. And so she said, what was the offer? And the school said, we will give you a flight ticket, make X amount of money payment and things like that, right? And subsequently, the offer was made to her on Friday. On Monday, she came back and said, I will take the offer to resign on agreed terms. The court actually found that, yes, the employee had resigned voluntarily. She had considered all her options. And in this case, her best option was to walk out of her employment because she couldn't guarantee her performance. And in her best interest was to actually take that flight ticket and that payment of that monetary sum and walk out of her employment, right? Or resign from her employment. And the court found it to be voluntary. So similarly here, it'll be the employee who will be raising it. The employee will see that, you know what, yeah, okay, fine, you know, I understand that I can no longer work here. the company will say, yeah, it's up to you, whatever option you want to take. If you want to resign and if you want to work a deal out, we can always talk about that as well. No issue. So that's how it will work.
Thank you, Mr. Amardeep. Vishnu, can you take over? Vishnu, you are muted. Can't hear you, Vishnu. Still cannot hear you.
And now?
Yes, okay.
Yes, we can.
Okay, yes, thank you so much, Mr. Amar, for a fantastic discourse on a presentation, very extremely informative. Just to mention, there was a question on deed of release. We ourselves have come across situations where employees these days are using deed of release, and they are very similarly worded to MSS, exact norm, exact clauses, and everything. So sometimes these are just mere labels to describe the same thing. MSS deed of release. Employees sometimes like to choose a different word to express the same desire to mutually terminate, to have a MSS or mutual separation agreement with the employee. But thank you very much once again, Mr. Amari, for the fantastic, extremely informative. And we're glad. I hope he's answered all questions. We'd like to see all of you again. And take care, stay safe, everybody, and goodbye for now.
Take care. Thank you very much for having me.